The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone, and welcome to this month's webinar in which we're going to focus on one area of the Employment Rights Bill, and that's all to do with zero-hour contracts. But before we get going, as usual, we do like to introduce ourselves. I'm Victoria Templeton, the HR Knowledge Manager here at HR Solutions, and I'm joined today by Sue Watson. Sue's our Operations Director, and together we're going to go through this topic with you. And because we have so many of you today on our webinar, we've placed you all on mute. However, as usual, we do want your involvement in today's webinar, and there's a couple of ways in which you can do that. So first of all, we'll be inviting you to ask us your questions, and we're aiming to answer as many as we can. But given the time we have and what we're going through, we may be limited to how many we can answer, but we'll do our best to get through all of them for you. And then on the screen now, you'll see an image of what your GoToWebinar question panel looks like. Simply type in your question, and then we'll aim to read out and answer as many as we can at the end. Another way that we like to engage with our audience is to make our webinars interactive by using polls. So these not only help steer the webinar, but it allows us all to share how that topic is being managed in our own workplace, and it can help to share ideas of best practice with everybody on the webinar today. So when you see this slide, it just illustrates we're going to be running a poll. They are confidential. We only publish the results to the questions, so we would welcome as many of you today sharing your insights with us. And in terms of our agenda for today, I'm going to just start off by clarifying what a zero-hour contract is today, what it looks like now, and then after which I'll introduce the reforms. We're going to then consider how these reforms could impact your business and therefore what strategies may be important for mitigating the impact that they could have. And as usual, we'll take your questions at the end, so please do submit, as I've said a moment ago, and we'll work through as many as we can in the time we have. So we're going to start off as usual with some introduction polls, and it's really just so that we can get an understanding of the audience with us today and to help steer the running of today's webinar. So first of all, it's about describing your business in terms of the size that you're operating in. So we'll just take a few moments to get your answers in that poll.
Okay, I'll close and share
Thank
that
you.
information.
So, okay, so medium 44%, fewer than 250, so predominantly SME type organisations, although 21% from the large organisations. So welcome everybody, and hope you find the session informative. The next question is around human resource management and who's responsible for it in your business. Okay, thank you.
Okay, so
yeah,
mainly in-house, mainly.
Yeah,
looks like from that one. Okay, so let's move on to the next one. There's one or two in this section we're doing, just to get the context for everybody on the call.
Yeah, and this is about the zero-hour contracts themselves or other forms of arrangement, as you may know it, casual workers. Do you employ them or engage with them?
Okay, so I think this is a resounding yes.
Yeah.
Yep.
Yeah.
Okay. And
Brilliant. And then it's the last one's really about the industry that you operate in. So the 85% of you.
Got one more after this, I think.
Yeah. Okay. Thank you. It's interesting to see the breakdown of where everybody's from.
Okay, I'll close and share that one.
Brilliant. Health,
Great.
social care, yeah. Hospitality, it's 11%.
It's quite high, isn't it?
Yeah, and then I did say if you wanted to let us know in the comments, then please feel free to do. So a large proportion actually of you
Mm.
have said
Okay,
that.
so hide that. And then the last one in this section
Yep,
is just about awareness of the reforms. Okay, I'll close and share that one. There we go.
lovely. So majority of you have that limited awareness, which is great that, you know, change is on the horizon. So I would say, I don't know what you think, Sue, but out of all the reforms, this is probably the most complicated and probably one of the significant ones.
Absolutely, because it affects such a high percentage of the workforce. So, yeah, absolutely, it's a key one, and it is a complex one. So
Yeah.
hopefully you can stay with us.
Please bear with us, yes. So let's get going. So I just wanted to set out, first of all, just 0-hour contracts as we know them now, because it's just helpful then to put some perspective in terms of the reforms. And I'm just having problems with my slides on. No, there we go. I think it's done it now. So in terms of 0-hour contracts, I mean, we use that phrase, but it could be known as a casual worker. It's about having a contract of employment or terms of engagement where there's no minimum level of work or pay. Somebody who is engaged or employed in that way, their employment status can differ. So you could engage workers or hire employees either on a contract of employment, and that's obviously where you are obliged to offer work and they are obliged to accept it, or they can be engaged on a more of a casual arrangement, which gives them a worker status. So you're not obliged to offer the work, and they're not obliged to accept it either. So sometimes 0 hours gets used in different contexts within organisations. So I just wanted to clarify that there is a distinction with employment status, how you call it. I think what's important is what's happening in practice as to their employment or engagement relationship with you. But essentially 0-hour contracts, I know it in my mind as being an employee employed on a 0-hour employment contract, but you can also have casual workers engaged on an agreement who are workers. But I just wanted to clarify that in terms of the terminology. The reforms that are coming down the line are complicated. We'll do our best to share with you what we know now as of today. But if you remember back to the Labour manifesto, their intentions were to set out to ban exploitative 0-hour contracts. But in reality, it isn't about a ban, it's about changing the way in which employers manage individuals who work on contracts or work agreements where there's no defined hours. And it's about tackling one-sided flexibility, enabling workers, employees to have predictable work and income. They are complicated. We will need regulations to be introduced for how we are to implement the legislation. And on top of this, there will almost certainly need to be a new ACAS code of practice drawn up to help guide us all. So we're going to share with you the position as it is of today, but there will be limits as to what I can set out and answer in terms of questions as well. So if we remember the Workers' Predictable Terms and Conditions 2023 Act, we did do a webinar on that. I was looking earlier, it was May last year. That came in, although the law came in, but it was never enforced or implemented. But it was about giving workers a statutory right to request a more predictable work pattern if their work pattern lacked predictability. With the new government coming in, they are repealing that piece of law, so it's never even going to be put into practice and implemented. But instead, they're using it almost as a basis to reform zero-hour contracts under the Employment Rights Bill. So it's almost like an adaptation of it. The aim of the reform is because currently workers have to be available to their employer but with no guaranteed work. Employers can schedule or cancel shifts with little notice, both of which can provide insecurity for workers in terms of income and work. So it's about trying to tackle that and remove that one-sided flexibility. So what the reforms are going to be doing is require employers to offer qualifying workers guaranteed hours. The right to guaranteed hours will apply to workers and employees. So if we think back to what I said a moment ago, regardless if it's a casual worker or 0 hours contract engagement, the right will be given to qualifying workers who are employed under the 0 hours contract or who have a low number of minimum guaranteed hours but work more than those in a reference period. It means employers will be obliged to offer new or varied contracts that reflect the hours worked during the reference period that is to be defined. But there won't be any obligation for the worker to accept any offer of guaranteed hours, but there will be clearly a defined framework drawn up as to how it will operate and what happens if a response is not received, etc. So it's not about removing 0 hour contracts, this particular reform. It's about banning those employers that exploit workers by not giving much notice and all things like that, and no regular work. So that's, I guess, an overview. This slide is illustrating a bit more detail. So it's letting us know that it's about ensuring all qualified workers have those guaranteed number of hours, which must reflect a number of hours worked in a defined reference period. So at the moment, we don't know what this reference period is, other than we can expect it to be probably 12 weeks. The government's preference, I think, is 12 weeks, but obviously we need further regulations and consultations to happen. But essentially, we will determine a set number of hours based on a person's reference period, the hours they've worked. A qualifying worker will be someone who has been employed under one or more 0 hour contracts or under a 0 hour arrangement for low hours. There will be limited circumstances where, as the employer, you're not obliged to offer guaranteed hours or you are able to withdraw it. But in those situations, the workers must be provided with notice. Now, this is one of the areas that we need clarifying in regulations. Then there's going to be obligations placed on the employer to make sure that they provide reasonable notice of shifts, as well as giving reasonable notice of cancellation of shifts or where there's a change to it. And the regulations, when brought in, will also provide detail about a new power to exclude duties or rights relating to 0 hour contracts for workers and agency workers who are under the terms of collective agreements. And again, we need the detail to understand what this means. And finally, the reforms will also see workers and employees being given greater protection through the Employment Tribunal court system, as well as the new Fair Work agency that's going to be introduced. So the Fair Work agency will have a remit, so they will be enforcing statutory pay rates being in place, which will include sick pay, but also 0 hour pay and things like that. So there's going to be far greater protections for employees and workers as well. There is a lot of uncertainty. The Department of Business and Trade do have a publication, which is a fact sheet, all to do with 0 hour contracts, setting out their intention in this particular policy area, and there's a link there. So a copy of these slides will be sent out after this webinar over the next few days, So there's a link there to that fact sheet. But as you can see on the slide there, it sets out really what it's about, trying to achieve, ending that one-sided flexibility, providing that baseline of security, giving predictability of work and hours, and giving greater clarity of an advance notice of working patterns to make it easier for workers in terms of just the practical side of coming to work, organising transport, making arrangements for family and caring responsibilities, and it's also encouraging employers to plan ahead. But there is uncertainty, and what you'll see here to the right of the slide, there are a number of significant questions that we need answers to. So how will that reference period be calculated? Over what period? What do we mean by reasonable notice when you're setting or changing somebody's shift? What is meant by moved or short notice in respect of cancelled, moved or curtailed shifts? What is meant by low hours? Who is a qualifying worker? And what are low hour contracts? These are all questions that remain unanswered because we need regulations to give us that clarity. And also the ACAS Code of Practice will also provide more practical guidance on how we apply the law and the regulations. So we've just got one quick poll coming up, and it's in relation to employment agency. And I bring this up because under one of the amendments that was brought forward in the House of Lords recently, is that employment agencies are included in this particular reform. And I'll come on to explain shortly.
Okay, I'll close and share that result.
Okay, brilliant. So fairly
significant number, yeah.
A significant number, yeah. So as I said, the bill is making its way through Parliament. Amendments obviously are submitted, debated, accepted or not. And one of the recently submitted amendments did get passed, and that is to extend the reform bill to employment agencies and agency workers. So, and that came on the back of a recent public consultation actually on this particular reform. So I'm going to just set out now what that will mean for you in practice. So employment agencies, both the employment agency and the end hirer, the employer, will be responsible for giving reasonable notice of shifts. And the employment tribunal will be able to apportion liability based on the responsibility of each party in each case. We also know that from a guaranteed hours perspective, it will be the end hirer who will have responsibility to offer guaranteed hours to qualifying workers. And when it comes to payment obligations, it will be the employment agency that will have responsibility to pay for any short notice, cancellation or curtailed payments. However, they will be allowed to recoup this from the end hirer, but only where they have the arrangements covering this between the two parties. And then when we think about the regulations that will be coming in, they are going to be providing the detail about how the rules are to operate in practice, and they are likely to include stipulations for the form and way in which an agency worker should receive notification of shifts, the cancellations and curtailments of shifts as well. So there will be some responsibilities placed on employment agencies, and as an end hirer perspective, it's going to mean that you're going to need to think about your operational working practices about how you work alongside employment agencies to make sure you're conforming to your obligations, and equally they will be wanting to ensure they're conforming to their legal obligations as well. So I did say this is very complicated, and hopefully it's making sense now. As I said, we are awaiting more detail, which will help, and we will provide further information and webinars, no doubt. So I mentioned earlier that the employees and workers will be given greater protection at tribunal. So just wanted to take you through this. So an employment tribunal claim could be brought where a worker is not offered the hours on the required terms or given the required notice. We know that 0-hour contracts are likely to fall under the remit of the new Fair Work Agency. And interestingly, a change to that particular reform recently was that when that is introduced, the agency will be able to raise a tribunal claim on behalf of the worker, even if the worker doesn't want to do it. So they're going to be given very strong powers to enforce this particular reform and the other reforms that fall under their remit. The Fair Work Agency will be able to bring, like I said, a claim on behalf of the claimant, and a claim could be raised where the employer is actually seen trying to avoid triggering the guaranteed hour rules that will be set out in the regulations. And as we know in other areas of employment law, what is reasonable, that is something that is always to be determined by an employment tribunal. We will need case rulings to help us understand the application of this law in practice. How is the letter of the law meant to be applied? And so it will take cases for us to better understand that. But ultimately, what is reasonable will be down for that employment tribunal to determine. Workers will also have the right not to suffer any detriment under these reforms. And on a side issue, the employment tribunal time limits are going to be extended, and that's probably going to be quite a quick reform that is implemented. So we could see that later this year, in theory. And they're going to be extending it from 3 months to 6 months. So that's something that's really important, particularly with this reform, that will be where people have greater protection and rights for tribunal claims. So let's look at some of the potential implications, which I'm sure, as we've been talking through the reforms, many of you will have started to think of some obvious practical challenges for your business. And I think, we believe the reform has a potential to massively impact employers in several ways. So if we first of all think about an increase in the administrative burden, employers are going to need to regularly review the working patterns of those that they employ on 0-hour arrangements in order to be able to identify those who qualify for guaranteed hours offers. And therefore, that's going to involve more tracking of the hours and more meticulous tracking of those. We also suspect that it's going to mean loss of flexibility. So employers could lose the ability to completely scale down their hours during quiet periods, risking that more fixed wage bill even when demand is low. And, move that on. Can you see my screen? Okay. And then the third one is the potential for overstaffing. So for industries where 0-hour contracts are a key factor in their recruitment, those with highly seasonal or unpredictable demand, employers might be obligated to provide hours even when there isn't enough work, and therefore potentially leading to overstaffing and increasing costs. Now, in terms of increased costs, this reform clearly has a direct financial impact. Employers are going to incur costs for shifts that don't happen or are shortened due to their operational changes, and of course costs associated with possible increase in employment misclassification. So if you remember right back to the start when I talked about is somebody classed as an employee or worker, the important thing is looking at how that relationship operates in practice. But if you get it wrong and you misclassify somebody, then there's more broader ramifications for the organisation in terms of tribunal claims, because obviously employment rights differ depending if you're a worker or employee. And then if we think about redundancies, if 0-hour contracts with a guaranteed number of hours are giving that set commitment to hours and pay, and then the business gets to a point where it needs to reduce significantly its business operations, then obviously that's brings up the question of possible redundancies, which that in itself comes with its own legal and financial implications. So there is that potential risk as well. And it probably goes without saying the need for workforce planning, which I'm sure is already happening, but it's about thinking more strategically about longer term staffing needs and how to utilise 0-hour contracts, and perhaps whether there needs to be a shift towards more fixed term or even annualised hour contracts where appropriate. And basically it will probably turn around your whole recruitment strategy and workforce planning, because you might have to think completely how you recruit and resource. And in considering recruitment, the scale of the reform is significant. So the reforms of 0-hour contracts do signal a fundamental shift away from the traditional model of maximum staffing flexibility. The obligation to offer guaranteed hours to workers who consistently demonstrate a regular working pattern will necessitate a more cautious approach to recruitment, potentially leading to increased reliance on precise workforce planning, as I mentioned, and forecasting, rather than having that hire and hopes sort of strategy. And consequently, we could see an increase in initial recruitment costs for businesses as they make that shift towards more formal contracts and away from that easily accessible casual staff, all of which pose challenges for sectors with highly fluctuating or seasonal demand that have historically relied on 0-hour arrangements, as I previously mentioned. But while the shift may present, I guess, an initial administrative burden in tracking hours, managing compliance, there actually are some tangible long-term benefits for retention. So employers who adapt effectively by providing greater predictability and security to the workforce, they're likely to experience improved employee engagement, high morale, and ultimately reduced staff turnover, which all in all can translate into significant savings, whether on recruitment costs, training costs in the long run, alongside a more stable, productive and loyal workforce, and also enhancing the employer's reputation and reducing legal risks associated with non-compliance. So there can be benefits that arise from changing the way in which you recruit and hire individuals as well. So we've got a couple of 2 or 3 polls now coming up, and it's just interesting to get everybody's views as to how you think these reforms are going to impact your business. And I know a high proportion of you on here today do use 0-hour contracts. So this should be a multiple choice poll question. And so let's share with everybody how we are feeling about these reforms.
Okay, I'll close and share that one.
And what are the results? So all high numbers. What's the largest one? Admin burden.
Yeah, admin burden and the loss of flexibility. Yeah.
I mean, do you have any particular thoughts, Sue? Or
no, but I think the reason that we use 0-hours contracts is for flexibility, and the fact that that's potentially what we're losing. As you said, it's a major rethink on how we staff our business. I think the costs are probably an unknown at the moment. There is a potential for increased costs, definitely, because you're guaranteeing a level of work that you might not be able to predict. But it will need a hell of a lot more planning and thinking about what do you really need. So yeah, some great questions coming around this. So
brilliant.
We'll perhaps pick up on it in a little bit. So I'll move on to the next one.
The next one is actually now pinpoint out of all of those, which would be your biggest challenge. Yeah, so hopefully it's not multiple choice. I hopefully set it up correctly, but
Okay.
There's a lot to get your head around with this whole reform.
Yeah.
Let's see.
Okay, let's close and
Yep.
share that one. So, yeah, the
Yeah,
flexibility
you're
is
right. Lots of
closely
flexibility.
followed by the administrative burden.
And that
Yeah.
makes sense, because that's the whole purpose, isn't it, really, of making use of 0-hour contracts, be able to
Casual workers.
deploy people as and when. Yeah,
Yeah.
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 But I guess what the government have found is that evidence suggests there's a lot of exploitative working practices.
Yeah.
And so it's about trying to balance that more for people, for workers. But yeah, interesting. Thank you. And then one final poll in this section is whether or not you're starting to prepare for the reforms, and actually not just this one. There's, I think, 27 others, roughly.
From the questions, there obviously is some crossover impact on some of the other reforms as well, such as
Yeah.
the employment tribunal timescales, the
agency that's coming in.
Yeah, agency and the fixed term working. So yeah, it's all kind of interrelated, isn't it?
Yeah.
Okay, I will close that poll and share these results. So there we go. So
oh, brilliant.
62% have
made
some progress.
Yeah, and for those of you that haven't, maybe you'll come away from today and it will at least plant the seeds in your mind about, how it could impact your own place of work. And planning sooner rather than later is probably my suggestion, and we'll come on to that shortly. So let's have a look first at strategies, and then I'll sort of talk through how we face the challenges ahead. So there will be many steps that you can take now to start preparing for these changes. And obviously for many of you, it sounds like you rely heavily on the 0-hours contracts. And this is a significant reform. I think the first piece of advice is, first of all, to carry out your own impact assessment of how not just this reform will impact your business, but all of the other ones. And what we mean by impact assessment is about considering all aspects of the business as a matter of course, starting with how will the 0-hour reform impact on people management and our workforce in general? How could the implications of this particular reform impact on the sales or service that we offer? What could the implications be for marketing and pricing? Will there need to be changes to the strategy in these areas? And what about IT and systems, as well as operational practices? You're likely to need to have to develop systems and processes that will make sure that you can comply with the law. And so the impact assessment is actually probably the very first step in the whole preparation for the reforms. We are developing template impact assessments, which will soon be launching, one specifically to 0-hour contracts, and it's going to provide you with a comprehensive list of questions, considerations to help you in understanding the full impact of the changes ahead. Now, the second strategy is around developing a strategic people plan. And I'm sure many of you have some form of people plan in place already, but actually there needs to be incorporated in this, or a new one entirely to do with the Employment Rights Bill and the reforms. And build into your strategic people plan the findings from your impact assessment, because it'll drive you to determining the appropriate actions. If you're a knowledge-based user, then you've got access to our template people plan in the document area, and you will also have the impact assessment as well as part of the service. But we also have a template people plan on our website as well for others to have access to. So these two things are really important in the planning for the reforms. And then in terms of, from a practical perspective, think about starting to develop working practices now, preparing for the reforms once they'll be enforced, for how they're going to be managed. So, for example, start regularly reviewing the working patterns of those that you employ on 0-hour arrangements. For example, we know roughly, it's highly likely that it'll be a 12-week reference period. You can do a lot of planning by looking over people's working records to see what actually were their hours worked in a 12-week period. I know we don't have the detail about the mechanics of how it's operated and what that looks like, but for the purpose of just preparing and taking that initial step, you know, that's probably something that would be worthwhile. And so it's about spotting now what processes you're going to need to adopt, what record keeping will you need to have in place for when the reforms come in. I'd also advise auditing your current workforce to identify the proportion that are engaged on 0-hour contracts, casual work arrangements, and in which area of the businesses that they work in, and then carry out a period of scenario planning. So we know the reforms will have cost implications. So it's going to be really important to start preparing now for that reason. And whilst, as I said, it's only an approximate view that you can gain at this stage, because we don't have the detail, it will ultimately help with your future planning, which leads us on to workforce planning. And for some employers, the reforms may lead to a significant shift in how they recruit, like we just mentioned a moment ago, and in terms of what type of employment arrangement. So it's really important to consider this now, so that you can think about what long-term staffing needs you'll have and how will you be able to meet them. And then finally, compliance is key, particularly as it will come under the Fair Work Agency that I've mentioned, and there's going to be greater protection available through the court system. So review existing systems and operational practices to ensure you're ready for compliance. Remember, even though we don't have all that detail, like I've said, there's enough information known at this stage to start gathering your thoughts and views and anticipating how your business might need to adapt and change. And as I said, it really all starts with your impact assessment. That's going to be your key tool at this particular point in time. So I thought I'd share with you some the possible timescales for guaranteed hours. This is what we anticipate needs to happen before the reforms can come into force, which is why I say there's time to prepare now. But it's important for you to just sort of get an idea as to what has to happen before we can get them implemented, because there is a lot. So first of all, the bill is still currently being debated. It's currently in the House of Lords. It's got a couple more stages before it then has to be passed back to the House of Commons for final amendment discussions, and then it gets passed over to be given royal assent. Now, there had been the potential for it to become a piece of law as early as July this year, but the bill is taking longer in the House of Lords stages, which means it's pushing timeframes back. So having, I obviously following this all the time, daily, the current view, I guess, in the legal community is that potentially we're looking now at the autumn 2025 for the bill to become an act of law, not necessarily all the reforms come in. I don't want to panic you. Because obviously we've got the summer recess as well, so Parliament closes down around the 22nd, 21st July. So as a bill becoming an act of law, let's say that then becomes autumn 2025. For this particular reform, we then need regulations drafting. So the government department will need to draft those. There'll need to be a public consultation, and then it needs to be laid before Parliament for scrutiny, debate and amendment. And then on top of that, there will need to be a new ACAS code of practice. So ACAS will need to develop and draft that new code based on the legislation. And even with this, there needs to be a public consultation as well. They'll then need to review that feedback from that consultation process and revise the code. And then they must lay that before Parliament. And in order for the ACAS code to come into force, it needs to be given an order by the Secretary of State. So I think it's fair to say there is a long way to go, which is why I say you have time to prepare, but I would still advise preparing sooner rather than later. We know enough now to think about longer term recruitment needs, resourcing methods and things like that, but and also from a budget point of view. If we know there's going to be more costs involved, then it's really important to start factoring that in, hence why the scenario planning is really key. So I suppose as a rough estimate, I'd be hesitant to say even next year that it would come in. It probably could be 2027 and beyond. I mean, it's so complicated, as you've probably gathered as I've tried to take you through the information. But yeah, we'll just have to keep an eye out and see. Which leads me on to this final slide, and that's about preparing the business for change. So I think what I would say is stay informed, understand the reforms over the coming months. And you can do this, you can follow us on socials, you can sign up to our email news updates via our website, or if you're a knowledge-based user, you receive our weekly emails and links directing you to updated content and news articles and events. So I think that's really imperative that you stay informed on what's happening. I also think that it's imperative that you carry out an impact assessment, because it's really important to understand how each of the reforms are going to impact your business. So I've mentioned they'll be available on the website, the knowledge base, etc. So just keep an eye out on that in the coming days and weeks. Consider your budgets and forecasting. You know, remember that scenario planning. Think about this 12-week reference period. As I said, I think it's the government's preferred timeframe for a reference period. Obviously that could change, but at least it gives you a starting point now to sort of do some scenario planning. Review your employee value proposition. So that's about how you present yourself to the job market, to your existing workforce. It's about how you remain competitive as an employer. With those anticipated increased costs, you're going to need to decide how to carry that burden of the additional costs. Do you absorb it as a business, or do you pass it on to customers and products through increased pricing? These are all things that are going to need some time to think through. Carry out that workplace audit that I mentioned of your current working practice. Address any gaps now in your employment processes, because that's going to help the business in good stead for then introducing the reforms. So factor risk audits into your planning, and we do have some available. Again, these are free tools available on our website, our HR risk audit, and it's also available if you're on the knowledge base user as well, because it's on there too. So do carry out your audit as well to make sure you're putting yourself in a good position right from the outset. Plus also you need to ensure that you're conforming now with current obligations. And then there's the piece about developing compliant policies and working practices, and that's all your employment documentation, like contracts, agreements. You know, do you have 0-hour contracts? Are you going to have a casual work agreement in place? What does that look like? Policies, as well as your day-to-day operational practices. And this is going to be a huge task that's going to need careful handling, planning, consultation with your workforce, and if you are unionised, you're going to need to work closely with your unions to keep them on side. So as I said, so engage and consult with your workforce. It's going to be vital to mitigate any attrition or recruitment challenges. Engage early, transparently, and take your employees with you through that journey of change. And I've put on here about reviewing existing relations with trade unions. This is going to be key, because not only do you need them on your side as you're navigating all of these reforms, but there are also going to be reforms to how trade unions are allowed to operate as well. So it's going to be a big area of reform. And then finally, and probably most importantly, I would say, is about training your workforce. And it's not just about training your line managers, your employees, but also your HR and payroll teams, because these reforms, not just the 0 hours, but all of the employment reforms, are probably the most significant in decades. And they're going to be new to everybody. We're all going to need to help each other. So I think always factor in training for your HR and payroll teams too. So I've got a couple of quick polls before we move to the questions, and it's really just to understand if there's any further information or support. If I think about particularly the 0 hours reforms, first of all, that you may look to need our help on. do let us know, because we can then look to contact you.
Yes, we've had a few questions around the impact assessments and
Okay.
how we will notify.
Yeah.
I think as Victoria mentioned earlier, if you sign up to our newsletters, if you're a new knowledge base subscriber, you will get information about as these are released, as the new documents and the new information are released. So yeah, sign up to keep in touch, and we'll keep you posted as things are.
Yeah. Okay. And then we've just got one final poll. It's just more generic about if you'd like us to follow up with you about our services in general after today's event, whether you'd love a conversation with us, whether any literature you'd like about our services, or not at this time. So do let us know.
Okay, I will close that now.
Yep. Lovely. And then what we'll do now is we'll move to questions. We've got a little bit of time, so be kind with me.
So there are a lot, and I'll try and group them together. So there's quite a lot of concern about the fact that quite often it's the employee stroke worker who has requested the 0 hours, such as university workers, university students during their holidays, people wanting to work it around other jobs. So they want the flexibility, and so alongside that, it's how will that sort of impact? Also, will the notice period to cancel, is that on both sides? Will do they have to? Will there be a minimum period by which they have to say they're not available, for example, or can you put that into your agreements? So I guess I don't know. Is there anything on the horizon on that are you aware of?
I'm not. This is the kind of detail we need from the regulations, and I suspect it will come out once the bill has been passed, so we probably won't know for some time in terms of length of notice periods. The point about whether employees would have to give notice, I think the main purpose of this reform is to balance to reduce the one-sided effect, if you like, that the evidence suggests there is out there. I suspect, I mean, and don't quote me, I suspect the notice is probably just the employer side. But I don't know.
Probably,
I don't know what you think, but that is purely as
whether you can
guesswork.
Whether you can justify including a notice period for cancellation on the other side. I would imagine if you have to give one, then you could quite fairly expect notice from the other way as well. So I guess it'll come out in the when we get the detail, as you say. And then it's sort of, the questions are also around can you combine a 0 hours with a sort of a fixed term contract? And it's all around, I guess that's also fixed with the seasoning, isn't it? The seasonal workers, which is another big area, such as wedding planners, and they've got no guarantee of what the work is at certain times of the year, but certain times they know it's going to be really busy, and how that affects the sort of periods, the reference periods, etc.
I think the fixed term might be a possible option, mightn't it then? So if you're employing, during the summer holidays and you want to take on a student, July through to early September, and then you have that defined set of hours in the contract. But how would you define the guaranteed hours?
Yeah.
This is what's all unclear.
Yeah, exactly. If there's somebody on a 0 hour contract and we offer a permanent contract, and then they turn it down, what happens then? I guess
the stuff I've read on that is about they can refuse the offer. But I think the intention is that the employer there'll be requirements of the employer to regularly reoffer.
Okay.
So it's not like you offer once and then that's it. If they've said no and then you don't revisit it. I think it'll be about, at regular intervals, the employer will be expected to reoffer, because it's trying to address the issue of unpredictability.
Yeah. And I think the question is also around knowing what to base the guaranteed hours on. And I think this whole question of the definition of reasonable comes in again, doesn't it?
Yeah.
I mean, if you have had previous seasons on which you can take an average, for example, and if there are more factors that influence it, such as it's a bad year weather-wise, so it affects harvests. If it's there's very, very many factors that affects whether a season is going to be high level or low level of hours. And I guess if you are basing it on a reasonable set of factors and use that as your indicator, then we would hope that that would be acceptable. But until we get the guidelines on and a definition on reasonable, I mean, they've never really defined reasonable in a lot of contexts, but they have started to more recently, haven't they? Because of people are pushing back on it, saying you actually need to give us more structure around the word reasonable, and we can use tribunal cases, not for these yet, but for past legislation, to give us an indicator of what a tribunal sees as reasonable. But as always, if it's going to be one of those that'll come out in case law, isn't it, eventually?
I wonder whether the ACAS code will incorporate some recommendations. You know how like they already do in other areas. So, you know, you can't define black and white what is reasonable, because organisations are different in terms of infrastructure, finances, the size, you know, the nature in which they work. There's just no way of having a defined list. It's not a tick box exercise, but I think we'll probably be seeing something in the ACAS code that what reasonable looks like, and then so guidance only. So we know, like, if you think discipline and grievance, the code of practice, we know what a reasonable process looks like because of the way they've developed their ACAS code, as well as knowing case rulings and the legislation. But I think perhaps we just have something like that.
Yeah, absolutely. I think that there are lots of questions, but they're all around those similar themes, and some of them we just can't answer at the moment because we don't have enough information or guidance. And as you've said, you know, a lot of it is around the planning and the kind of assessment of where you are, doing the impact assessment, understanding all the factors that are going to affect your decision on whether to use continue using 0 hours workers, and how you're going to form the kind of guaranteed element of that, and how you're going to define it, and then just be prepared so that when the legislation comes in and we have the guide from ACAS, you'll be in a better position to act fairly quickly on it, because you'll have already done your planning and you're prepared, because sometimes they don't give us a huge amount of time to implement these things. Which is why, because it's such a significant change, we need to start thinking about it now. And in the context of other reforms, there are a couple of questions around the impact of the increase from 3 to 6 months for tribunal claims, and the 2-year rule.
Massive.
Because and that will absolutely have an impact on these contracts or agreements. So hence the short-term dismissals is a whole other area of up in the air now because of the changes in the employment tribunal timescales and definitions. So
lots of change on the horizon.
I think so. Okay, so I think that's all we can cover at this moment in time.
Okay, brilliant. Thank you, Sue, and thank you for those questions. Really interesting. So if you'd like to keep in touch with us, please do. That'd be great. You'll see the details here, and there's a QR code on the screen. Please do get in touch with us, and we'll be more than happy to help you. And then I mentioned our knowledge base, so that's our online HR resource. And on there, we deal with all the template documents you can ever possibly need for managing an employee, setting up a business, and it covers the whole employee life cycle. So you've got contracts, letters, agreements, guides, forms, checklists, and then of course there's also a suite of articles that keeps you informed of everything to do with the employment life cycle. So there's a QR code there, so please do get in touch if you'd like to find more out more about that. And then we are continuing with our webinar schedule. So next month we're going to be looking at the slightly different aspect of the Employment Rights Bill, and that we're going to be looking at family-friendly leave and preparing for more flexible working requests. Then in August we're going to be looking at probation periods and how they may change in the future. And September we're going back to a bit more of a business as usual, if you like, the four primary, sorry, get my words out, areas of discrimination. October we're going back to the reform bill and looking at how businesses, we can protect businesses from tribunals. November is all about budget implications on human resource management and the things you need to consider for going into next year. And then December we like to incorporate a webinar about planning and organising for the year ahead, and this one is going to be about planning for change. So do sign up and register to our free webinars. It'd be great to have you join us. And then we're offering a free 30-minute consultation with one of our experienced HR advisors. So if you have a performance issue, you're dealing with absence, or looking at changing your workplace culture, then do try us out and you'll get a free 30-minute consultation. So do check out that QR code there. I'll be happy to help support you. And just to finish then, just want to thank you all for attending. Thank you for taking time out. I know it's extremely a busy period for everybody. Thank you to Sue for supporting in the Q&A and the running of the webinar with the polls and everything. And we look forward to welcoming you next month for our webinar. So have a good day, everybody. Thank you.